Also got 8 minutes. Go ahead.
Thank you very much. This bill is very welcome, and I congratulate the Minister on doing it. I've had, as my colleagues have as well, had a large number of submissions from members of the public, most of them female couples. So this is a very important matter, and I'm very glad that the Minister is addressing it. Now, she does say that some of this depends on the introduction of sections 2 and 3 of the Children and Family Relationships Act, and I note that the Minister of Health is working on that. Now, I very much hope that this will come into play pretty rapidly. And I notice also that Section 11 makes a technical amendment to Section 27.5 of the Children and Family Relationship Act that will allow the Minister of Health to commence parts 2 and 3. Now, what I have to say today is largely about the Children and Family Relationships Bill, because I think it's extremely important in welcoming this bill to herald some of the problems that may be experienced. And I would very much like the Minister, if she would be kind enough to take this part back to the Minister for Health for his consideration. Because we're talking about the area of donor-assisted human reproduction, commonly known as DAHR, and surrogacy. Unfortunately, there are a number of provisions in parts 2 and 3 of the Children and Family Relationship Act once commenced, and the Assisted Human Reproduction Bill 2017 once enacted, that will operate to treat certain children less favourably than others. These issues are not only of concern to children born to same-sex parents, but to many other children who are born through DHR and surrogacy. It's acknowledged that the children's right to identity is of primal concern and of great importance, but it's important to acknowledge also that upholding the child's right to identity does not require that a donor who has no desire or intention to play any role in the child's life should be recognised as a legal parent. I think this is a nonsense. If you have a donor, the material for creating the child is donated. Why should that person who has expressed no interest and doesn't want to be involved, why should they be recognised as a parent? That's problem number one. So I have a number of recommendations on which I've been briefed to put before the Minister. Number one, where a child is conceived through non-clinical DAHR, procedures should be in place to recognise the second intended parent as a legal parent. 2, a retrospective application for a declaration of parentage in cases of DAHR under Section 20 of the CFR Act should be possible where a known donor was used. 3, to ensure that the intended parent is recognised as a legal parent, the second intended parent, in cases where she provides her egg to enable the conception of the child. The words, unless the donor of the gamete or embryo is the spouse, civil partner or cohabitant of the mother, should be added to all sections of the CFR Act that currently provide that a donor of a gamete or embryo that is used in a DAHR procedure is not the parent of the child born as a result of that procedure. The Government should consider possibilities for recognising DAHR conducted abroad after parts 2 and 3 of the Act are commenced, because that's another area which is still grey. Provisions should be acted to retrospectively recognise the legal parentage of children born through surrogacy before the AHRE bill is enacted. The AHR bill should provide recognition of the legal parentage of children conceived through surrogacy conducted outside the state after the AHR bill is enacted. Preconception court orders should be provided for in the AHR bill to provide parental approval of the surrogacy arrangement and to determine the parentage of the child before conception takes place, with no requirement for a parental order to be obtained after the birth of the child. Some people suggest that adoption is a solution here. I don't accept that at all. Adoption wasn't designed to be used in cases of assisted human reproduction or surrogacy, and doesn't accurately reflect the reality of family life. So I don't see any reason why it should be used. Now, if we take, for example, the question of the known donor outside of a clinical setting, I'd just like to put a case study on the record. Elaine, the birth mother, and Jenny conceived their baby as a girl at home using sperm donated by Jenny's brother. They had no problem conceiving and did not need any clinical intervention. Their donor is happy to give consent to both women being recognised as legal parents. As their baby is only 3 months old, Jenny is unable to seek guardianship under the CFR Act 2015 as the child is less than 2 years old. Therefore, as the law currently stands, she has no legal relationship to her child and is unable to establish a legal relationship until her daughter is 2 years old. So that's a really significant gap, where there is no legal parent. And I think that really does need to be addressed. Now, other jurisdictions have looked at these situations, and for example, in the United Kingdom, a statutory presumption of parentage operates in favour of same-sex married couples and civil partners. We look at the situation of the known donor in a clinical setting in respect of a child conceived before Parts 2 and 3 of the CFR Act are commenced. For children who are conceived prior to the commencement of Parts 2 and 3 of the CFR Act, parentage may be retrospectively allocated to an intended parent not previously recognised as a legal parent through application for a declaration of parentage under Section 21 or 22 of the Act. In order for the declaration to be granted, the donor must have been and remain unknown to the intending parents at the time of the application. I think this is daft. Why should it be unknown? I think that is an unnecessary criterion to introduce into the legislation. I think it should be got rid of, particularly in the light of the fact that the phrase unknown is not defined in the legislation. So it also is in a grey area. This approach penalises couples who choose to use a known donor in order to safeguard their child's right to identity. And again, I can put a case study on the record. Jane, the birth mother, and Sarah have an 18-month-old baby boy, Jake. Jake was conceived in a fertility clinic using sperm provided by an identifiable donor. Jane and Sarah want Jake to know about his origins, and so they have obtained identifying information about the donor so that they can educate Jake about his genetic background. And this is really important. You need to know these things. Why have this thing about unknown donor? Well, there could be medical situations involved. There could be genetic disorders, all this kind of stuff. This information should be available. They should be known. The women have never met the donor but know his name and last known address. Jane is the birth mother of Jake and is recognised as the legal mother. After Parts 2 and 3 of the CFR Act are commenced, Sarah will be unable to obtain a declaration of parentage listing her as the second legal parent because a known donor was used. So I suggest, I'm just coming to an end. I'd like, if I may, with your indulgence, to end with a male case study, just for the idea of balance and diversity. The case study is this. Lawrence and Eddie have 6-year-old twins, which they conceived using a surrogate mother in the United Kingdom, not in Ireland. Eddie is the legal parent of the twins. The woman who is a surrogate for the couple is in regular contact with the family and is happy to consent to Lawrence being recognised as the twins' legal parent. One of the children has significant health issues and needs regular medical attention, and while Lawrence does have guardianship of both children, this does not recognise his parental relationship to them, which has huge implications for the family. As Eddie explains, I have a little boy with a rare genetic disorder which will mean that he will need care after his other dad's guardianship ends when he's 18. So we have another crux there, and I do understand that I didn't directly address, except very briefly, the terms of the bill the Minister is introducing to the House, but I think it's very important to get these to the Minister for Health in advance of the preparation, which is apparently well on the way. Thank you very much.
Thank you very much, Senator Norris.